The courtroom fell silent as Congresswoman Jasmine Crockett stood up, her voice cutting through the tension like a blade. What happened next would send shockwaves through the entire legal community and leave Justice Ketanji Brown Jackson completely speechless. In a moment that nobody saw coming, the Texas Democrat who had built her reputation on fierce advocacy was about to challenge one of the most respected legal minds in America. The disagreement that followed wasn't just about law. It was about the future of justice itself. Before we dive into this incredible story, make sure to hit that subscribe button and ring the notification bell so you never miss moments like these that are reshaping American politics. Now let's see how a single question turned into the most talked about legal confrontation of the year. The packed hearing room buzzed with anticipation. Legal experts, journalists, and political insiders had gathered to witness what they thought would be a routine oversight hearing. But Jasmine Crockett had other plans. Armed with documents that would challenge everything, she was ready to make her mark on legal history. This wasn't just about politics. This was about principle, precedent, and the very foundation of how justice works in America. And what Justice Brown Jackson said in response would change everything. To understand why this confrontation matters so much, you need to know who these two powerhouse women really are, and what brought them to this explosive moment. Jasmine Crockett represents everything bold about the new generation of Democratic leadership. At just 43 years old, the Texas Congresswoman has already made waves as one of the most fearless voices in Congress. A former civil rights attorney who cut her teeth fighting for justice in Dallas courtrooms, Crockett never backs down from a fight. Her background as a defense attorney taught her how to spot weaknesses in arguments and exploit them with surgical precision. She's known for her lightning-fast wit and her ability to dismantle opponents with facts and fury. Remember when she went viral for her epic takedowns during committee hearings? That same energy was about to be directed at one of the most powerful women in America. On the other side sits Justice Ketanji Brown Jackson, the first black woman ever to serve on the highest court in the land. At 54, she represents the pinnacle of legal achievement. Harvard Law School graduate, former federal judge, and now Supreme Court justice. Her credentials are unquestionable. She's known for her methodical approach, her deep respect for legal precedent, and her careful, measured responses. But here's what makes this confrontation so explosive. Both women are trailblazers. Both are brilliant legal minds and both believe they're fighting for justice. The problem is they have completely different ideas about what justice looks like. The stakes couldn't be higher. This isn't just about two accomplished women disagreeing. This is about the direction of American jurisprudence, the role of activism versus restraint in the legal system, and whether progressive ideals can coexist with judicial tradition. The setting was a congressional oversight hearing focused on judicial ethics and transparency. What was supposed to be a routine examination of court procedures was about to become a battle for the soul of American law. The cameras were rolling, the legal community was watching, and neither woman knew they were about to make history. Crockett had spent weeks preparing for this moment. Her legal team had uncovered inconsistencies in recent rulings that she believed exposed fundamental flaws in how the court approached certain cases. She wasn't just looking for answers, she was looking for accountability. Justice Brown Jackson, meanwhile, had expected the usual respectful questioning that comes with oversight hearings. She was prepared to defend the court's decisions with the same scholarly approach that had earned her respect throughout her career. She had no idea she was walking into an ambush. The hearing started normally enough. Justice Brown Jackson sat at the witness table, composed and professional in her dark judicial robes. The committee members took their seats and the chairperson called the session to order. The first few questions were predictable. Budget concerns, administrative issues, the usual congressional oversight routine. But then Jasmine Crockett's turn came. She adjusted her microphone, shuffled through her papers with deliberate precision, and looked directly at Justice Brown Jackson. The room sensed something different in her energy. This wasn't going to be another softball question about court procedures. Justice Brown Jackson, Crockett began, her voice steady but charged with purpose. I want to talk about your recent opinion in the Henderson case. The Henderson case, a complicated dispute involving voting rights and state election procedures, had been one of the court's most controversial decisions in recent months. Justice Brown Jackson had written a careful, measured opinion that tried to balance competing interests. Most legal scholars praised it as thoughtful jurisprudence. Crockett saw it differently. Your opinion, she continued, talks about the importance of respecting state authority in election matters. You wrote that federal courts should be reluctant to interfere with state-level decisions unless there's clear constitutional violation. Justice Brown Jackson nodded slightly. This was standard legal doctrine. Nothing controversial here. But then Crockett dropped her first bomb. Justice Brown Jackson, how do you square that position with your previous statements as a circuit judge, where you wrote that voting rights require aggressive federal protection and that state restrictions should be viewed with deep suspicion? The room stirred. This wasn't just a policy disagreement. This was an accusation of inconsistency from someone who clearly knew the law inside and out. Justice Brown Jackson maintained her composure, but legal experts in the audience could see she was caught off guard. She had expected questions about administrative matters, not a deep dive into judicial philosophy and apparent contradictions in her reasoning. Congresswoman Justice Brown Jackson replied carefully. Each case must be evaluated on its specific facts and legal context. The Henderson case presented different circumstances that required Crockett cut her off smoothly, a technique she'd perfected during her days as a trial lawyer. Different circumstances. Justice Brown Jackson. I'm not talking about different facts. I'm talking about different principles. In your circuit court opinion in Morrison versus Texas, you wrote that any restriction on voting access should trigger the highest level of constitutional scrutiny. But in Henderson, you applied intermediate scrutiny to nearly identical restrictions. That's not about facts. That's about a fundamental change in your judicial philosophy. The tension in the room was now palpable. Other committee members shifted in their seats. The C-SPAN cameras captured every moment. Legal Twitter was about to explode. Justice Brown Jackson's measured demeanor remained intact, but her response revealed the pressure she was feeling. Congresswoman, I respectfully disagree with your characterization of my reasoning. The legal standards I applied in both cases were consistent with Supreme Court precedent. And again, Crockett interrupted this time, pulling out a thick folder of documents. Let me read you your own words. Justice Brown Jackson from Morrison versus Texas. Quote, when fundamental rights are at stake, courts cannot defer to state preferences. We must act as guardians of constitutional principles, not passive observers of political convenience. End quote. She looked up from the paper, her eyes locked on the justice. Those were your words just 3 years ago. But in Henderson, you wrote that courts should respect the democratic process and avoid substituting judicial preferences for legislative judgment. Justice Brown Jackson, which philosophy represents your true beliefs? The room was dead silent. Every legal expert present understood what was happening. This wasn't just oversight. This was a public examination of judicial consistency that could have massive implications for future cases. Justice Brown Jackson took a deep breath, clearly recognizing that her answer would be scrutinized by legal scholars for years to come. Congresswoman Crockett, I believe both statements reflect consistent judicial principles applied to different legal contexts. The role of a judge is not to have personal beliefs about policy outcomes, but to apply the law as written and interpreted by precedent. It was a careful diplomatic response, but Crockett wasn't done. She pulled out another document, this one with multiple highlighted sections. Justice Brown Jackson, let's talk about precedent. In your Henderson opinion, you cited Baker versus Carr as support for judicial restraint in election cases. But Baker versus Carr actually established that federal courts have a responsibility to intervene in election disputes when constitutional rights are threatened. You cited the case for the exact opposite principle that it established. Gasps could be heard from the gallery. Legal experts were frantically checking their phones, looking up the Baker case to verify Crockett's claim. Within minutes, legal Twitter was confirming it. Crockett was absolutely right. Justice Brown Jackson's face showed the first crack in her composed facade. She had made a significant error in legal reasoning, and it had been exposed on national television by a congresswoman who clearly knew the law better than anyone had expected. I would need to review the specific context of that citation, Justice Brown Jackson said slowly, clearly stalling for time to think. Crockett sensed blood in the water. Crockett sensed blood in the water. Justice Brown Jackson, this isn't about context. This is about accuracy. You misrepresented a foundational Supreme Court case in an opinion that affects millions of Americans' voting rights. How do you explain that? The question hung in the air like a challenge. Other committee members were leaning forward, recognizing that they were witnessing something unprecedented. Never before had a Supreme Court justice been so directly challenged on their legal reasoning in such a public forum. But Crockett wasn't finished. She had one more surprise that would turn this hearing into a legal earthquake. What happened next would be replayed in law schools for decades to come. Crockett reached into her briefcase and pulled out a slim blue folder. She opened it with deliberate ceremony, making sure everyone in the room understood that something significant was about to happen. Justice Brown Jackson, she said. her voice now carrying the authority of someone who knows they're about to deliver a knockout punch. I have here the original draft of your Henderson opinion obtained through proper legal channels. The room erupted. Legal experts knew that draft opinions are rarely made public and never during active controversies. How had Crockett obtained this document? Justice Brown Jackson's eyes widened slightly. The first time her composure had truly cracked, Crockett continued. This draft written in your own hand and dated 6 weeks before the final opinion contains reasoning that is completely different from what you ultimately published. In fact, your original draft supports the exact opposite conclusion. She held up the document so the cameras could see it, though she was careful not to reveal specific content that might violate confidentiality rules. Your original draft opinion would have struck down the state restrictions as unconstitutional violations of voting rights. You wrote, and I quote, "The evidence clearly demonstrates that these restrictions disproportionately harm minority voters and serve no compelling state interests. The Constitution demands we protect the franchise, not defer to discriminatory state laws." The silence in the room was deafening. Even seasoned political reporters were struggling to process what they were hearing. But then something changed, Crockett continued, her voice rising with prosecutorial intensity. 6 weeks later, you published an opinion that reached the opposite conclusion, using legal reasoning that contradicted your initial analysis. Justice Brown Jackson, what happened in those 6 weeks that caused you to completely reverse your position? Justice Brown Jackson's face had gone pale. This was uncharted territory. Never before had a Supreme Court justice been confronted with evidence of such a dramatic change in judicial reasoning. Congresswoman, she began, her voice less steady than before, the judicial process involves careful consideration and revision. It's not unusual for opinions to evolve as justices engage in collegial discussion. And Crockett interrupted with surgical precision. Justice Brown Jackson, this wasn't evolution. This was a complete 80 reversal. Your original opinion contained 37 citations to voting rights cases. Your final opinion contained only 12, and 8 of those were used to support conclusions opposite to their original meaning. She pulled out a chart that her staff had prepared, showing the stark differences between the two versions. More importantly, your original opinion included a detailed analysis of expert testimony about the discriminatory impact of these laws. That analysis completely disappeared from your final opinion. Instead, you wrote that such evidence was speculative and insufficient. Justice Brown Jackson, how does expert testimony go from compelling to speculative without any new evidence being presented? The legal experts in the room were frantically taking notes. This was the kind of revelation that could reshape how people understood the Supreme Court's decision-making process. Justice Brown Jackson straightened in her chair, clearly recognizing that she needed to regain control of the situation. Congresswoman Crockett, I resent the implication that my judicial reasoning is somehow improper. The Supreme Court's deliberative process is designed to ensure that we reach the most legally sound conclusions possible. If my opinion evolved during that process, it's because careful analysis led me to a more correct understanding of the law. It was a strong response delivered with the authority of someone who had spent decades in the legal system. But Crockett had one more card to play. Justice Brown Jackson, she said, pulling out yet another document. I have here the conference notes from the case properly obtained through Congressional Oversight Authority. These notes show that your position changed not because of legal analysis, but because of pressure from other justices who threatened to issue a more extreme opinion if you didn't modify your approach. The room exploded. Committee members were calling for order. Reporters were typing frantically, and legal experts were shaking their heads in disbelief. Never before had the inner workings of Supreme Court deliberations been exposed in such detail. Justice Brown Jackson's face showed genuine anger for the first time. Those conference discussions are confidential for good reason, she said, her voice sharp. They allow justices to engage in frank dialogue about complex legal issues without fear of political repercussions. Your decision to make them public violates fundamental principles of judicial independence. Crockett leaned forward, her eyes blazing with the intensity of someone who had spent years fighting for justice in courtrooms across Texas. Justice Brown Jackson, judicial independence means independence from political pressure, not independence from accountability. The American people have a right to know if Supreme Court decisions are being shaped by internal politics rather than legal principle. She stood up, a move that electrified the room and signaled that she was about to deliver her final argument. You took an oath to uphold the Constitution and administer justice without fear or favor. But the evidence shows that you abandoned a legally sound position protecting voting rights because other justices pressured you to conform. That's not judicial independence. That's judicial cowardice. The words hung in the air like an indictment. Never before had a member of Congress so directly challenged a sitting Supreme Court justice's integrity and courage. Justice Brown Jackson rose to respond, her face flushed with emotion. Congresswoman, I have served this nation with honor and integrity for over 2 decades. I will not sit here and allow you to impugn my character or my commitment to the law based on your misunderstanding of judicial process. But Crockett wasn't backing down. Justice Brown Jackson, I'm not questioning your character. I'm questioning your consistency. I'm questioning whether the justice who wrote that brilliant original opinion protecting voting rights is the same justice who published a final opinion that undermines those very protections. The American people deserve to know which version represents your true judicial philosophy. The confrontation had reached its peak. Two brilliant legal minds, both committed to their principles, facing off in a battle that would define how Americans understood their highest court. What happened next would shock everyone in the room. Justice Jackson stood silent for nearly 30 seconds, an eternity in political time. The cameras captured every moment of her internal struggle. When she finally spoke, her words would send shockwaves through the legal establishment. Congresswoman Crockett, she said, her voice quiet but clear. You are right. The room erupted. Committee members gasped. Reporters scrambled for their phones, and legal experts looked at each other in complete disbelief. A sitting Supreme Court justice had just admitted to changing her legal position under pressure. But Justice Brown Jackson wasn't finished. You are right that my final opinion in Henderson did not reflect my initial legal analysis. You are right that I allowed concerns about court unity and political perception to influence what should have been purely legal reasoning. And you are right that the American people deserve better from their Supreme Court. The admission was unprecedented in American legal history. Never before had a Supreme Court justice publicly acknowledged that their published opinion had been compromised by internal political considerations. Crockett, for her part, looked almost stunned by the admission. She had prepared for pushback, for deflection, for legal technicalities. She hadn't prepared for complete honesty. Justice Brown Jackson, she said, her voice softer now. What you just said takes extraordinary courage, but it also raises serious questions about how the Supreme Court operates and whether the American people can trust that your decisions reflect legal principle rather than political calculation. Justice Brown Jackson nodded slowly. Those are fair questions, Congresswoman. Questions that I've been wrestling with since the Henderson decision was published. The pressure to maintain court collegiality, to avoid 5-4 splits that might appear political, to present a unified front. These considerations shouldn't influence legal reasoning, but the reality is that they do. She paused, looking directly at the cameras. I became a lawyer because I believe in justice. I became a judge because I believe in the rule of law. But somewhere in the process of joining the Supreme Court, I allowed institutional concerns to override my commitment to legal truth. That was wrong, and I regret it. Regret it. The legal community was in complete meltdown. Within minutes of her statement, law professors were posting analysis on social media, calling it everything from a watershed moment in judicial transparency to a dangerous precedent that undermines court authority. Former Attorney General Sarah Williams tweeted, Justice Brown Jackson's admission is either the most honest moment in Supreme Court history or the most damaging. Either way, it changes everything. Harvard law professor Michael Chen posted, in 30 years of teaching constitutional law, I never imagined I'd see a Supreme Court justice publicly admit to compromising their legal reasoning for political reasons. This will be studied for generations. But the immediate political implications were even more explosive. Republican Senator Tom Bradley immediately called for Justice Brown Jackson's resignation. If a Supreme Court justice admits to letting politics influence their decisions, they have disqualified themselves from serving on our highest court. Democratic Senator Maria Rodriguez defended her. Justice Brown Jackson's honesty shows the kind of integrity we need more of in our institutions, not less. The problem isn't her admission. It's the system that created the pressure she described. Within hours, Duchess's gate was trending on social media. Legal Twitter exploded with debates about judicial independence, court reform, and whether Brown Jackson's admission had permanently damaged the Supreme Court's credibility. The immediate aftermath in the hearing room was equally dramatic. Committee Chairman Robert Johnson, clearly overwhelmed by what had just happened, called for a 15-minute recess. During the break, Justice Brown Jackson's security detail had to escort her to a private room as reporters and photographers surrounded the witness table. When the hearing resumed, Crockett had one final question. How do you restore public trust in the Supreme Court's decision-making process? Justice Brown Jackson's answer would reshape American jurisprudence. Congresswoman, I believe the Supreme Court needs fundamental reform, not in its constitutional role, but in its internal processes. The American people deserve to know how we reach our decisions, not just what those decisions are. We need transparency in our deliberations, accountability for our reasoning, and an end to the kind of internal pressure that led to my error in Henderson. She looked directly at the camera. I'm announcing today that I will be working with legal scholars, good government groups, and members of Congress from both parties to develop proposals for Supreme Court reform that will ensure what happened to me never happens again. The room was stunned into silence. A sitting Supreme Court justice had just called for reforming her own institution on national television. The political implications were immediate and massive. Within hours, every major news organization had the story as their lead. Supreme Court justice calls for court reform after admitting to political pressure. Read the breaking news banners. Legal scholars were divided. Some praised Justice Brown Jackson's unprecedented honesty and called her a reformer who could help restore trust in the judicial system. Others argued that she had violated fundamental principles of judicial conduct and undermined the court's authority. Professor Elizabeth Martinez of Yale Law School wrote in an emergency blog post, "Justice Brown Jackson has done something remarkable. She's chosen truth over institutional protection. Whether that helps or hurts the Supreme Court in the long run remains to be seen." But perhaps the most significant reaction came from the other Supreme Court justices themselves. Within days, Chief Justice Roberts issued an unusual statement, defending the integrity of the court's deliberative process while notably not mentioning Justice Brown Jackson by name. Justice Thomas went further, writing in a rare public letter, "Recent events have damaged the court's reputation and violated our traditions of confidentiality. Such behavior cannot be tolerated if we are to maintain public trust." The split within the court became public knowledge, something that almost never happens. Legal experts began speculating about whether Justice Brown Jackson would face formal censure from her colleagues, or whether she might resign under pressure. But Crockett had achieved something unprecedented. She had forced a Supreme Court justice to publicly admit that political considerations had influenced legal decisions. The question now was what Congress and the American people would do with that admission. In the weeks that followed, Crockett became a legal celebrity. Law schools invited her to speak about judicial accountability. Legal magazines profiled her as the Congresswoman who changed the Supreme Court. Progressive groups hailed her as a hero who had exposed the truth about judicial politics. Conservative groups, meanwhile, argued that she had overstepped congressional authority and undermined separation of powers. Senator Bradley introduced a resolution condemning her questioning as an unprecedented attack on judicial independence. But the broader implications went beyond politics. Justice Brown Jackson's admission had opened a door that couldn't be closed. For the first time in American history, the public had concrete evidence that Supreme Court decisions could be influenced by factors other than legal reasoning. The Henderson case itself became a symbol of everything wrong with the current system. Voting rights groups began calling for the decision to be revisited in light of Justice Brown Jackson's admissions about how it was decided. Meanwhile, Justice Brown Jackson found herself in an impossible position, having admitted to compromising her judicial reasoning. She faced criticism from both sides. Conservatives who said she was unfit to serve and progressives who argued that her reformed approach didn't go far enough. But she also found unexpected support. A group of former federal judges wrote an open letter praising her courageous honesty and calling for the kind of transparency she advocated. Several law schools announced new courses on judicial accountability inspired by her testimony. The confrontation between Crockett and Brown Jackson had lasting consequences that extended far beyond that dramatic hearing room. It changed how Americans thought about their Supreme Court, sparked a national debate about judicial reform, and established Jasmine Crockett as one of the most effective oversight members in congressional history. 6 months later, Congress would pass the Judicial Transparency Act, requiring Supreme Court justices to provide detailed explanations for any changes in their legal reasoning between draft and final opinions. It was a direct result of what happened in that hearing room. When a Texas Congresswoman decided to hold power accountable, the legislation itself became a model for judicial reform efforts in other countries. The European Union's Court of Justice began studying the American approach, and several national Supreme Courts adopted similar transparency measures. Legal scholars noted that what started as a single congressional hearing had sparked a global conversation about judicial accountability. The law's implementation wasn't without challenges. Some justices initially resisted the new requirements, arguing that they would chill deliberative processes and make collegiality more difficult. But public pressure fueled by ongoing coverage of the Crockett-Brown-Jackson confrontation made resistance politically impossible. The first annual report under the Judicial Transparency Act revealed shocking statistics. In the previous year, Supreme Court justices had made substantial changes to their reasoning in 23% of cases between initial drafts and final opinions. Most changes were minor clarifications, but several revealed the kind of pressure-driven compromises that Justice Brown Jackson had described. The report also showed that cases involving politically sensitive topics were 3 times more likely to undergo significant revisions, supporting Justice Brown Jackson's claims about institutional pressure affecting legal reasoning. Perhaps most importantly, the data revealed that justices appointed in recent decades were more likely to change their positions under pressure than those from earlier eras, suggesting that the politicization of confirmation processes had created justices who were more sensitive to political considerations. The legal experts who witnessed the confrontation still debate its significance. Some argue that Crockett saved judicial integrity by forcing honesty about the court's problems. Others contend that she damaged the institution beyond repair by exposing internal dynamics that were meant to remain private. Constitutional law professor Dr. Rachel Thompson wrote in her definitive analysis of the hearing, "The Crockett-Jackson confrontation represents either the beginning of a new era of judicial transparency or the end of judicial independence as we've known it. History will judge which interpretation proves correct, but everyone agrees on one thing. The day Jasmine Crockett confronted Justice Brown, Jackson changed American law forever." The hearing also had unexpected effects on legal education. Law schools began requiring courses on judicial ethics and accountability. Moot court competitions started, including scenarios about internal court pressure and judicial compromise. A new generation of lawyers was being trained to think critically about judicial institutions rather than simply river them. The American Bar Association revised its Model Code of Judicial Conduct to include specific provisions about resisting institutional pressure and maintaining intellectual honesty in opinion writing. State judicial conduct boards began investigating complaints about judges who appeared to change positions for political rather than legal reasons. The final irony: 6 months after her testimony, Justice Brown Jackson authored one of the most celebrated Supreme Court opinions in recent memory, a voting rights decision that protected minority voters with the exact reasoning she had abandoned in Henderson. Legal scholars called it a masterpiece of constitutional interpretation. When asked about the opinion, Justice Brown Jackson simply said, "Sometimes you have to be called out to find your way back to the truth." And Jasmine Crockett, she's already preparing for her next oversight hearing, armed with documents and questions that promise to shake up another powerful institution, because as she learned that day in the hearing room, sometimes the most important battles for justice happen not in courtrooms but in the bright lights of congressional accountability. The story of their confrontation reminds us that in American democracy, no one, not even Supreme Court justices, is above being questioned when they forget their duty to the Constitution and the people they serve. But perhaps the most lasting impact of that extraordinary day came from something unexpected: the inspiration it provided to young lawyers and law students across the country. Within months, enrollment in constitutional law courses spiked at law schools nationwide. Students who had viewed the Supreme Court as an untouchable institution suddenly saw it as something they could help improve through rigorous legal analysis and courageous questioning. The First National Bar Association reported a surge in applications from young lawyers interested in public service roles that involved judicial oversight. The Crockett effect, as legal educators began calling it, was inspiring a new generation of lawyers to see government accountability as their calling. Professor Sarah Martinez at Columbia Law School noted, "My students are asking different questions now. They're not just learning what the law says, they're learning to ask whether legal institutions are living up to their stated principles. That's the kind of critical thinking that strengthens democracy." Even the Supreme Court itself began to change. However, slowly and reluctantly, Chief Justice Roberts announced new internal guidelines requiring justices to document any significant changes in reasoning between draft and final opinions. While these documents wouldn't be made public immediately, they would be preserved for historical analysis. More importantly, the court began issuing more detailed explanations for its decisions, often including dissenting perspectives. Even in unanimous cases, legal scholars noted that opinions became more thorough, more carefully reasoned, and more willing to acknowledge competing viewpoints. Justice Brown Jackson herself became a different kind of judicial figure. Her subsequent opinions were models of transparency, often including extensive footnotes explaining her reasoning process and acknowledging potential counterarguments. She began giving rare interviews to legal publications discussing the importance of judicial honesty and accountability. The confrontation also had an unexpected effect on congressional oversight more broadly. Other committee chairs began adopting Crockett's approach of thorough document review and detailed legal analysis. Executive branch officials found themselves facing much more sophisticated questioning about their decision-making processes. Even corporate executives testifying before Congress noticed the change. One Fortune 500 CEO privately told colleagues, "These aren't just politicians asking questions anymore. They're coming prepared like trial lawyers. It's a whole different ballgame." The ripple effects continued for years when the next Supreme Court vacancy opened. Senate confirmation hearings included unprecedented detailed questioning about judicial philosophy, internal pressure, and commitment to transparent reasoning. Nominees who might have coasted through previous eras found themselves facing grueling examinations of their legal consistency. And Jasmine Crockett. She became something unique in American politics. A member of Congress known primarily for the quality of her legal preparation rather than her partisan rhetoric. Colleagues from both parties began seeking her advice on oversight strategies, and law firms started recruiting from her staff, knowing they had been trained in rigorous legal analysis. The day she confronted Justice Brown Jackson changed more than just one Supreme Court case or one justice's approach. It changed expectations about accountability, transparency, and the kind of preparation required to effectively challenge power in America. Years later, when law students study that hearing, they learn not just about judicial ethics or congressional oversight, but about the power of thorough preparation, courageous questioning, and the fundamental democratic principle that no institution, no matter how revered, is above accountability to the people it serves. Thanks for watching this incredible story unfold. If you want to see more moments like these, where accountability meets power, make sure to subscribe and hit that notification bell. The battle for transparency in our institutions is far from over, and you won't want to miss what happens next when principled leaders like Jasmine Crockett continue fighting for the truth that our democracy demands. He demented.